So what it does is create an opportunity for unique situations to give superintendents the ability to provide kids who really need to be relocated to another school for some reason, the opportunity to go to that school for that reason. It's not, well, I'm just going to answer the question instead of editorializing about it, you know. So.
I think there was a mix-up because he was talking about JCE, but you're talking about JCA.
Oh, I'm sorry, what?
JCE is manifest hardship. He had asked about JCE.
Okay, I was talking about JCA, and I thought you were talking about how the two work together.
I was talking about JEC, where the sole responsibility of the superintendent, if a request is made for that superintendent to determine if it's in the best interest for that student to be assigned to another school that they're not currently attending.
Okay, that's JCA. Best interest is JCA.
Okay.
JEC, and I apologize about that, JEC is the Manifest Educational Hardship Statute. And that Manifest Educational Hardship Statute is different from the best interest of the child standard, where there's no appeal and the superintendent gets to make a decision that is not appealable. Policy JEC and the Manifest Educational Hardship Statute create a right of parents to seek reassignment to another school based on their ability to prove a manifest educational hardship. And if they're able to prove that manifest educational hardship, the school district is obligated to make available to them attendance at another school. I will say this, however, and this is important to note, one of the things that's clearest in school law in New Hampshire is the fact that no school district, public school district, is obligated to accept any student who's not a resident of their student school. Notwithstanding any other law to the contrary, the law reads in RSA 193.12, a school district, public school, is not required to accept any other student from another district. So there's actually even some question that, well, I'll leave it at that.
Becky, I just have two more questions and I'll stop.
All right, wait.
If I may.
Nope, I'm going to cut you off because I want to make sure, because I want to be fair and make sure if there are other people in the audience who would like to ask a question, who haven't had a chance, and I'll go back to you.
That's fine.
Okay, thank you.
Hi, Jessica Baker. Can you define for us what a manifest educational hardship is?
I will do my best, because fortunately, this is one I don't have to define myself because the State Department of Education has done so in ED 320. ED 320 is the state rule. ED 320 are the State Department of Education's rules that have the same force and effect of law that are adopted by the State Department of Education to implement the laws that the legislature has passed. So it's we call it a rule, you can call it a regulation. If a parent or guardian thinks the attendance of a child at a school to which such child has been assigned will result in a manifest educational hardship to the child, a parent or guardian may apply to the school board for a change of school assignment to attend another public school in the same district or attend a public school in another school district. In order to apply for the school, to the school board for a change of school assignment based on manifest educational hardship, a parent shall demonstrate the detrimental or negative effect on the pupil if the pupil continues to attend the school to which he or she is assigned. If a school board determines that manifest educational hardship has been found, the school board shall issue a waiver of the school assignment. That's essentially what they do. And the student shall be reassigned to a reasonably available public school in the district or in another district. So they waive the assignment. So they've said the school board ultimately decides, kids, you're going here, or this youngster is going to go to this school, and the school board would issue a waiver. Here's the thing. Each school board shall establish a policy which shall allow a school board, with the recommendation of the superintendent, to take appropriate action, including but not limited to assignment to a public school in another district when manifest educational hardship is shown. I'm giving you the whole thing because it's not very long. Now, the local school board issuing a finding of manifest educational hardship, well, no, excuse me, I'll read it correctly. The local school board shall issue a finding of manifest educational hardship if it determines that there is clear and convincing evidence. And I'll just talk about that very briefly because all these words are important. Clear and convincing evidence is not a preponderance of the evidence. Clear and convincing evidence, so it's higher than a preponderance of the evidence, which is a basic weighing of the evidence, and once the evidence is weighed, it tips slightly in one favor or another. Clear and convincing is that the scales of justice are tipped, and you can see them tipped. The other standard of proof that you have in cases is beyond a reasonable doubt. You hear that all the time on your police shows. Beyond a reasonable doubt is the jury has no reasonable doubt, the trier of fact has absolutely no reasonable doubt, and these are the facts. So, just letting you know that. And the standard is this, that a substantial portion of a pupil's academic, physical, personal, and social needs, all four of those things, a substantial portion of a pupil's academic, physical, personal, and social needs cannot be met by the assigned school and are not found within the student body of the assigned school. Number two, that the assigned school's failure to meet the pupil's needs will impair the educational progress of the pupil. And number three, that another public school, either within the district or in another district, may reasonably meet the pupil's educational needs. The last section is, if a parent or guardian is aggrieved by the decision of the school board, it can appeal to the state board in accordance with the provisions of ED 200. Okay? You want me to go over that one more time, or did you get them all? So the standard is clear and convincing evidence of, number one, a substantial portion of the pupil's academic, physical, personal, and social needs cannot be met by the assigned school or are not found within the student body of the assigned school. Number two, that the assigned school's failure to meet the pupil's needs will impair the educational progress of the pupil. And number three, that another public school, either within the district or another district, may reasonably meet the pupil's educational needs.
Yes.
I would just like to clarify that Mr. Graham is correct, but in the policy JCB, manifest educational hardship is not mentioned. It's educational hardship, and that's quite different. So under the policy that he was quoting, that is correct, but this district is not forced to use that policy in the reassignment of our high school students. We do have a contract, and this policy, JCB, says educational hardship, which has not been defined. And I would add that this policy has not been revised since that point. So the fact that the board may have started using ED 320, the policy itself remains the same and says educational hardship, does not mention manifest educational hardship or ED 320. So just to be clear, we need to remember which policy we're talking about. Thank you.
Could I just add something real quick also?
Yes, remember that you're both serving on the school board.
Yes.
Yeah.
I just want to make sure that we're clear between, as Mr. Pro said, about the two policies. And the JEC, Manifest Educational Hardship, doesn't have anything really to do with assignment of students to high school. It has to do with every student of every grade of every school in New Hampshire has that same right, that if there's a manifest educational hardship or they think there might be one, that they can have that right to transfer or to do that procedure and prove it and remove. But it might not have anything to do with, I mean, that JEC policy is for every student of every school. Thank you.
I hope I made that clear.
So that really, but I just wanted to-
No.
Hi, I'm Tracy Humpy. Can I share something with the board? Do I have permission to approach? I just have a copy that I can share with you. That I would make, but I want you to have it. You are welcome. This is what I holding out. This is the hearing officer report and recommendation overview from the hearing that we had for my son Justin. This case involves a parental request to the Hooksett School Board to assign their child to Bow High School. Hooksett has a maintenance agreement with the Manchester School District that obligates Hooksett students to attend Manchester high schools, but permits Hooksett students to be assigned to other high schools on a case-by-case basis. The parents are also parents of an older student. Several years ago, the Hooksett School Board or superintendent approved the parent's request to send the older student to Bow High School. Apparently, the Hooksett School Board or superintendent approved virtually every parental request for assignment to other schools in years past. Due to a change in Hooksett School Board members, the board recently decided to change the practice of pro forma approvals for change of assignment requests. Starting on November 1st, 2011, the Hooksett School Board changed its policy on dealing with these parental requests to assign students to high schools other than Manchester. The new school board policy now permits assignment to a high school other than Manchester only if the parent can demonstrate an educational hardship. The parent in this case was the first parent to request a change of assignment under this new policy. The parent's requested issue here is for their second child who will be attending high school in the fall of 2012. The Hooksett School Board denied the request, saying that the request did not meet the criteria under the new policy. The new policy does not define educational hardship. The school board did not use the manifest educational hardship definition in RSA 193.3 and Ed 320.01 or any other definition with objective standards or criteria to assess the parent's request. Instead, it uses subjective, we know it when we see it approach to make its determination. There is no principled way for the state board to review a local school board decision based on such an approach, and it lends itself to arbitrary and inconsistent results. As a result, I recommend that the state board remand the matter back to the Hooksett School Board to develop a definition and criteria for assessing educational hardship under their new policy and allow the parent to prevent evidence to the Hooksett School Board to attempt to meet that standard. If the Hooksett School Board is unable to do that in a timely enough manner to consider the parent's request for the upcoming 2012-2013 school year, I recommend that the prior policy be used to assess the parent's request so that the student's acceptance of Bow High School is not lost due to inaction. Now, this is a third-party subjective person, so I'm asking the school board now, not the lawyer, Mr. Graham, just the school board, to look at your policy. It's flawed per a third party, and I'd like you to revisit my son's case and approve him under the prior policy. Thank you.
Other,
May I ask, he's at 3 already, if I may? Before Mr. Lazar.
No.
Oh, I didn't see Mr. Green, by all means.
yes, I'm just trying to make sure that everyone who wants to ask a question gets at least one in before we go back. Thank you.
When it's my time.
Okay.
I actually have a couple of questions, and I'll make them they're all real short, they go together. The first one would be to the attorney, and that would be, Kim Regan. As the attorney for our school board and our school district, do you not have any concerns, whereas everything that you've read us today said that the superintendent is the one that would review the case and make his recommendation to the board on a case-by-case basis? Do you not have any concerns that, although I respect all of you and I know you're here for us, that these folks are not educators? We've hired all of these people that you see to be educators for our children. They know our children, they know our children's cases, they know all about them. How can they make the decision on a case-by-case basis, hearing personal information from some of our citizens that really should have been presented through Dr. Littlefield with his recommendation? Are you not concerned for the board has a lawsuit coming to them? Each of these individuals could put themselves at risk for a lawsuit if something happened to one of these children and they voted no. Are these not a concern to you?
I'm always concerned about liability of board members, districts, and anyone. I'm not concerned, though, in this instance when a board has a responsibility for making decisions under its own board policy. A board has the ability to adopt a policy to designate who it wants to make decisions. Once it's done that, it's obligated to make those decisions. By law, and I don't want to confuse this by going back to the manifest educational hardship all the time, but by law, for example.
But I think you are confusing it. Manifest educational hardship is different.
All right, I'm going to ask you not to interrupt when someone's speaking.
But under manifest educational hardship, for example, it is the board's responsibility as defined by the legislature to make that determination. Boards sit in determination of individual